The appeals proceedings in the case of the prosecutor versus Jean-Pierre Bemba Gombo continued from Tuesday 9th to Thursday 11th January 2018 at the International Criminal Court in The Hague. Following the appeals chamber's order of 27th November 2017, the parties and participants were invited to address 6 different groups of issues related to the appeals by the defense against the conviction decision, as well as the appeals by the defense and the Office of the Prosecutor against the sentencing decision in the Bemba case. Throughout these appeal hearings, the defense, the OTP, and the legal representative of victims were given the opportunity to briefly present their views on legal questions posed by the appeals chamber. Among the issues discussed during the hearing, the parties and participants gave their views on evidentiary matters, the facts and circumstances included in the documents containing the charges, the legal requirements to establish criminal responsibility of military commanders, the definition of crimes against humanity, and the sentence imposed on Mr. Bemba by Trial Chamber 3. Regarding evidentiary matters, the defense of Mr. Bemba criticized the approach and the reasoning of Trial Chamber 3 in assessing the evidence presented at trial.
The trial chamber's approach to evidence was unbalanced. For no articulated reason, the trial chamber ignored important evidence on central issues. Also, in the submission of the appellant, viewed in its totality, the trial chamber's approach to evidence was inconsistent as between the defence and the prosecution, and incompatible with a proper application of the burden and standard of proof.
On the contrary, the OTP and the LRV supported the trial chamber's conviction decision.
Barring a material error or a lack of reasoning, neither of which, and despite the defence's arguments, both in their brief and this morning, despite their arguments and claims that there was a lack of reasoned opinion, this does not come out from the judgment. We've exhaustively dealt with this in our response brief, so I won't go into the details on each point that he's raised, but essentially the appeals chamber should defer to the trial chamber's assessments on the credibility and reliability of evidence.
The debate continued in relation to the facts and circumstances included in the documents containing the charges and the conviction decision by Trial Chamber 3. In the view of the defense, the conviction decision was partly based on acts that were not included in the documents containing the charges.
Clearly, Fact 1 is a factual allegation which will require to be proven at trial. A witness will require to come and say that there was a rape of P22 in a particular location on a particular date. That fact just doesn't stand alone. It's not just evidence in and of itself. It requires to be proved. How? By evidence. It's also a fact which will require to be proven beyond reasonable doubt.
For the OTP, Bemba was charged and convicted of crimes of murder, rape, and pillaging committed by MLC soldiers between 26th October 2002 and 15th March 2003 in the Central African Republic. The OTP argued that these were the facts that needed to be proved beyond reasonable doubt. The LRV, on the other hand, argued that some specific facts help to demonstrate contextual facts.
The consequence is that the rapes committed by the soldiers of the MLC in the CAR between the 26th of October 2002 and the 15th of March 2003 constitute a contextual fact, while the rape of witness P22 at PK11 is a specific incident that justifies the existence of the contextual facts in the charges.
The appeals chamber also presented questions related to the definition of crimes against humanity, in particular, the reliance of Trial Chamber 3 on the war crime of pillage when studying whether there was an organizational policy to attack the civilian population by the MLC when determining Mr. Bemba's responsibility for crimes against humanity was discussed during this appeals hearing. In relation to these questions, the defense submitted that the war crime of pillaging cannot be considered when examining the alleged commission of crimes against humanity.
That the organisational policy described by the trial chamber is nonsensical and unsustainable. What are the composite elements of an organisational policy? And it may be appropriate at this stage to highlight that we're moving into question B. Can a trial chamber rely on the war crime of pillaging to establish that there was an organisational policy? According to the elements of crimes, an attack directed against a civilian population is understood to mean a course of conduct involving the multiple commission of acts referred to in Article 7, paragraph 1 of the statute against any civilian population pursuant to or in furtherance of a state or organisational policy to commit such attack. Accordingly, the attack needs to involve the multiple commission of acts referred to in Article 7, paragraph 1, and therefore not multiple acts of pillage.
In contrast, the RTP argued that, given the manner in which the MLC committed crimes against the civilian population, the trial chamber reasonably relied on acts of pillage when examining the commission of crimes against humanity in the case against Mr. Bemba.
Was the chamber also reasonable with the facts at hand to do so? Not surprising, our position is that yes, it was reasonable. The chamber found that many acts of rape and murder were committed during the course of the MLC pillaging. The MLC acted following a consistent modus operandi: the search house to house, pillaging goods, raping civilians, intimidating and killing those who resisted.
Lastly, the defense and the Office of the Prosecutor presented their arguments in relation to their own appeals against the sentencing decision, and the LRV was allowed to give its comments on the discussion by the parties. On the one hand, the defense requested that Mr. Bemba's sentence be reduced.
What are the facts about this conviction? What is beyond dispute? Mr. Bemba didn't participate in the crimes. Unlike many commanders at the ad hocs, he wasn't standing there amongst his troops, encouraging them or participating as they murdered civilians. He didn't order the perpetration of crimes. He didn't intend the crimes to occur. He wasn't motivated by any particular religious or ethnic hatred. He didn't have any discriminatory motive. He didn't share the intent of the soldiers that committed the crimes. His culpability arises from his failures regarding a fraction of his troops fighting in a foreign conflict thousands of miles away.
On the other hand, the Office of the Prosecutor pleaded for an increase in the sentence imposed by the trial chamber.
In this case, the individual sentence for the rape of 28 victims does not reflect the gravity of the 3 murders and the pillaging of 25 individual victims and 6 groups and institutions. This is so regardless of the fact that all crimes, again, were committed in the context of the same conflict and by the same armed groups. The direct murder victims were not raped. Neither were many of the indirect victims of murder. Their victimization, their harm is entirely based on different crimes. Similarly, about half of the individual pillaging victims, as well as the 6 pillaged groups and institutions, were also not raped. It was therefore wholly unreasonable for the chamber to conclude that the 18 years for the crimes of rape alone reflects the totality of Mr. Bemba's culpability.
The legal representatives of victims also gave their comments on the appeals presented by the parties against the sentencing decision.
The convict should be found guilty and pay for his acts proportionately to the crimes perpetrated. For the victims, sentencing Mr. Bemba to 18 years does not correspond to the accusations against him and the seriousness of the crimes. There are victims who felt that it was as if Mr. Bemba simply killed one individual, whereas in this case, these are widespread cases or crimes. Another victim went even further by stating that this was an insult.
After the debate on the different legal issues presented by the appeals chamber to the parties and participants, Mr. Bemba was given the opportunity to address the chamber. Even though he did not address the chamber directly, his lead defense counsel spoke on his behalf.
But Mr. Bemba does not wish to address the court directly, but what he does wish me to do is to express his profound gratitude to everybody in the courtroom and those who detain him, but in particular to your honours for your obvious compassion, interest and care in dealing with his appeal. He's very grateful indeed to you.
Thank you, Mr. Bemba.
This concluded the hearings scheduled at this stage in the appeals proceedings in the case of the prosecutor versus Jean-Pierre Bemba Gombo.